families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to this week's episode of Families Divided TV. Tonight, our guest presenter will be Bill Eddy with the High Conflict Institute. He's going to be speaking to us about working with lawyers in alienation cases. You're going to want to have a pen and paper because this is really good. In this 30-minute presentation, Bill Eddy explains 3 types of family lawyers, their knowledge or not of alienation issues, finding a lawyer, and working with your lawyer. He also briefly reviews the 5-factor model and how it can help clients give useful information to their lawyer. Working with your lawyer and using experts is also addressed. Again, you're going to want to take notes. This one is really good. We're going to be right back with Bill Eddy right after this message.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Hello. So I'm going to present today for 30 minutes on working with lawyers in alienation cases. And while there's a lot of discussion of mental health professionals and counselors, evaluators, etc., I think it's also important to talk about lawyers because there's really a range of lawyers, and it helps to be aware of some of the issues and potentials, possibilities. So I'm going to start by focusing on 3 types of family lawyers. And keep in mind that each side has a lawyer, usually in alienation cases, but not always. But usually because they're complicated and both sides have very strong feelings, and so you want someone as I'll describe. So first of all, there's the aggressive lawyers. And the temptation is to seek the most aggressive lawyers. But as I'll explain, that doesn't always do the best for you. So what I find, and I should mention that I was a lawyer for 15 years in family court, and then I did primarily mediation for 15 years. And then the last 4 years, I've been focused on training, teaching, consulting, and writing. So I've had a lot of experience with court cases. And what I can say is the most aggressive lawyers often all they want to do is win. They don't care really about the case, the child, even their client to some extent, because they're so focused on winning. That's just part of their personality. That's part of who they are. And so they'll do almost anything. And I've had cases where, to me, they've crossed the ethical boundaries. But in most cases, they go up to the edge, but then they don't cross over. So the temptation is to get someone like that. If you do, be aware that sometimes they alienate the judge because of their aggressive tactics. They may stretch things, although whether they stretch them to a false statement or just an implication. So they may say things about the other side that are very strong worded, criticizing the other side as a person, and saying the other side is doing hostile things, venomous things, etc. So be prepared for that, especially if they're on the other side. This is how some lawyers operate. They may use procedures to manipulate, delay. A lot in alienation cases is, where is the child now? So if the child is with the other parent and you're trying to even get access and any time, they may be very aggressive about keeping you shut out of the child's life and using procedures to delay and keep things as they are. If the child is with you and the other side is trying to get time with the child, and you have an aggressive lawyer, they may say, well, I'm going to manipulate things so the other side doesn't get much contact. But frankly, in the long run, that's really harmful to the child. You want the child to have time with the other parent, even if the other parent's not a very good parent. Having a relationship, having time with that parent actually gives the child a realistic picture of that other parent. So they don't have a fantasy, maybe that the other parent's wonderful when they're not having contact with that parent, or that the other parent's awful. So these are just things to be aware of depending on the position you are in the case. Some of the most aggressive lawyers can be what I call negative advocates. So they advocate for the negative behavior of their client. If you get a lawyer like this, they may have a reputation for being a negative advocate. And so some people, such as judge or mediators, evaluators, etc., may be concerned about you if your lawyer's one of these negative advocates. So I guess all put together, I want to say be cautious about getting this kind of lawyer, even though it looks good. And on TV, of course, the most aggressive lawyers sometimes win dramatically, and it's tempting to want someone like that. But be cautious about that. And it may be that you'll have a lawyer like that, and that's the best lawyer around for you. But just be aware that they may do some things that backfire on you. And so you want to have a kind of a good working relationship so they don't go too far and perhaps alienate the court. The assertive approach, and I'll just say right now, this is what I recommend. And this is the approach that I tried to have my 15 years in family court, and that a lot of the people I teach, I recommend this approach. And that is, they're right on top of the case, and they understand the case and know what the best outcomes may be. They know the court, they know how the judge tends to think, the court system. So for example, in some states, they're really moving towards 50-50. In other states, they don't consider that, or they think that that won't work. And if you have a parallel parenting case where the parents don't interact, the percent of time really can vary. And I've spoken about this in some of my other webinars or presentations. So that can be a good approach, but you want a lawyer that knows all of these options. You want them to respond to criticisms, attacks, and in these cases, they're often as extreme criticisms of you, for example, or your family members, etc. So you want someone who's prepared to respond to those, and just keep on top, set the record straight. Don't let negative statements about you go very far. You want someone that knows the procedures, but will use them to accomplish positive things rather than just to destroy the other side and win, even though there's a temptation for that. In my experience, and I do a lot of consultation today, and I do a lot of speaking to judges. And my sense is the judges really want reasonable attorneys. They want attorneys that know what's going on, know the court system, and aren't going to be escalating conflict unnecessarily, but sticking up for their client. And so the judges respect, I think, the assertive lawyers the most because they do come across as reasonable and not overly dramatic, as the aggressive lawyers sometimes do. Now, you want someone that's comfortable going to court. So the assertive approach, they're comfortable going to court and using procedures to get information out to the court, not to mislead or distort things, but to get useful information out, and that they're assertive about getting that out. In my definition, aggressive is where someone tries to win and have the other person lose. Assertive is where the person wants to prevail, wants to protect what's best without harming the other side, but without allowing oneself to be harmed. The passive approach is there's some lawyers that I would put in this category in terms of alienation cases. They may not like the case. They may be uncomfortable fighting about this because they don't really understand the dynamics of it. And they may see that the court is leaning towards the other side and don't want to alienate the court. Well, the trouble is in these cases, alienation is generally getting compared to child abuse or domestic violence, which are real issues. And the court has to sort out what's going on. Is this an alienation case, a child abuse case, a domestic violence case? Why is the child resisting contact? And if you're dealing with judges who have kind of a leaning one way, it's like, well, child's probably resisting the father because the father's done something wrong or inappropriate or is a very poor parent. And so they come in with that possible attitude, and you want to overcome that. And so if you have a more passive lawyer, they're going to say, well, you just should settle your case. The judge isn't really open to hearing about your point of view. And it's not supposed to be that way, and it's not spoken out loud that way, but that's the reality. Is some judges already have kind of a perspective that they come into these cases with. Alienation, even after 30 years, is a very confusing issue for family courts and family law professionals. So you get some judges who aren't really understanding of the dynamics. And if you have a lawyer that's kind of passive about asserting what's really going on, they may want to stay out of court and just have this case go away quietly. So I don't recommend that either. I think what you want is the more assertive approach. This lawyer may be friendly and comfortable, this more passive lawyer, but what I see with family lawyers is that there's a hesitance to use the courts unless they feel really strong in their case. And in alienation cases, they often don't feel that strong, especially because you can't see what's going on with alienation. It's often behind closed doors. It's the repetitive patterns. It's the emotions, etc. So just be aware that these are possibilities. So let me just talk about their knowledge of alienation issues. And this really varies, and it doesn't necessarily fit with the aggressive, assertive, and passive lawyers. So you may have an aggressive lawyer who knows very little about alienation, but they're good at fighting and arguing and and sounding strong without much knowledge base. So you will have some that have substantial. Frankly, I think the best lawyers in alienation cases have substantial knowledge of alienation, are also the assertive, and also have knowledge of abuse and domestic violence so that they know the difference. They can distinguish between these and be able to explain why this is an alienation case rather than a child abuse case or a domestic violence case. So you want, ideally, someone that's broad like that. In general, you want a lawyer who's got at least 5 years experience, so they know they've been in family court, and ideally the judge is aware of them and who they are and is respectful and interested in what they have to say. I'd say the majority of family lawyers today don't have substantial knowledge. And even though I'm not representing clients in family court at this point, I do a lot of consultation, and over again, running into cases where the lawyers really don't understand alienation very much. They may know a little bit, but more they're defending the client and saying, this is what's, my client never would do this, or my client has always done that. My client hasn't abused the child. The child's resisting because of what the other parent's doing. But they don't know the dynamics, and so they can't describe in detail what the behaviors are. And alienating behaviors are really what we talk about in this field now. We don't use the parental alienation syndrome in family court. It's a turnoff. The judges don't believe in it. The therapists generally don't believe it's a syndrome. And so you want a lawyer that can talk about alienating behaviors. So if they have a moderate knowledge, they may know about alienating behaviors. They may know about the 5-factor model. And I'll explain that in a little bit so you can provide evidence that helps them. They may not be aware of the 5-factor model and yet have had alienation cases and done okay with them. So most are in the moderate, but some have very minimal knowledge, and may have little or no court experience with alienation cases. And they may be willing to argue without knowing much about that. But as I said, the more they know about the nuances, the more they can say why yours is an alienation case and not a domestic violence or child abuse case. Because if they just ignore those issues, then they may come back to bite you. But they want to be able to address why it is or isn't, or maybe there was an incident that was scary, maybe could be called abuse, that's been resolved and taken care of. You want to address that rather than pretending it never happened, because the courts generally, in many ways, really respect people who are able to admit mistakes and move on, rather than people that can't acknowledge things that may have gone wrong. So knowing that there's a real range of knowledge is helpful, and I'll get to questions to ask. So, finding a lawyer. So, as I said a few moments ago, I think 5 years experience at least. This is something, the more experience with alienation issues, the better. Ask if they, but let me just say, most people aren't. People say, well, can you give me the name of a lawyer who really knows alienation issues and can handle my case in some small community in a particular state. And I don't know. I can't tell you who that would be. Judges tend to respect lawyers who they know. So you want someone local. You want someone that knows the local rules. But ask them, do you prefer to settle your cases or go to court? And the best lawyer will be doing both, because you want them to know how to take the case to court if necessary, and how to settle the case out of court if possible. That will save you money, save stress on the child. But in a lot of alienation cases, it's a high conflict because the other side's saying things that aren't accurate, and that needs to get pointed out. And so you may need to use the courts. So you want someone that's comfortable going to court, but you don't want someone that only goes to court and is unable to negotiate and understand how you can benefit your clients like that. Ask what their experience is in handling a case like yours. Give them a little background and say, have you had cases like this? And what would the normal steps be for handling a case like this for that person? What would they do? How would they gather information? Would they, push for trial? Would they want to get discovery, get a lot of information, and then see whether to negotiate, or try negotiation first and see if you have to really prepare for court a lot? There's a wide range in all these cases, but these are questions to ask. There's no one right answer. Ask if they believe most abuse allegations are true or not true, and ask about alienation allegations. Because I've had true and false abuse cases, true and false domestic violence cases, true and false alienation cases. There's some cases that really are child abuse or domestic violence, but look enough like alienation that some people argue, oh, well, this is clearly alienation, when the deeper we dig, it becomes clear, no, this isn't alienation. So there are false allegations of alienation cases, and you need to be aware of that to protect yourself if you're in an alienation case, to be able to say why this is different and give your lawyer information like that. So see if they have experience that tilts one way or another, etc. And ask how you could be helpful in handling the case. Some lawyers are more or less open to information. I've had lawyers who are good at communicating with their clients but know very little about alienation or, say, about high conflict personalities, and yet they're open. You can give them an article. Sometimes I recommend that you give them one of my books and pick a chapter that you think will help them. I'll mention now, and at the end, I have a book called Splitting: Protecting Yourself While Divorcing Someone with Borderline or Narcissistic Personality Disorder. And in there, there's a chapter on working with your attorney. And I suggest is give this to your lawyer and see if they agree with what it says or how you can be most helpful in the case. Gathering information, sharing background knowledge that may be like an article or something. See if they're open to that. Now, the consulting attorney category. Some people can't afford a full-time lawyer, and they'd like to get consultation from time to time. And there are more lawyers doing that nowadays. But a lot of lawyers won't do that. So what you have to do is find out who does that and how do they work. They may do an hour consultation with you to tell you how to prepare your case. If you're representing yourself in court, you really should consult with an experienced family lawyer so that they can tell you what to prepare for, how to prepare your papers. Maybe they can help you prepare your papers, and talk about questions to ask and talk about statements to make in court. So you're not going in cold. And especially if the other side has a lawyer, it's really recommended you have a lawyer too representing you. But some people don't. Nowadays, majority of cases, I would say, from what I've heard, in most cases, most states now, majority of people going to family courts represent themselves. Some of that's easy cases. but alienation cases are hard cases. Probably a majority of people in contested alienation cases do have a lawyer. So you want to strongly consider that. Now, sometimes it helps to get a lawyer you consult with at first, but who's available to represent you if things need that person to represent you. So you may do a 1-hour consultation just to see, are you someone I can do consultation with, and then have you become my lawyer if necessary. The more flexible the lawyer in working with you, the better it may be in terms of how you work together. But sometimes the most flexible lawyers don't actually know a lot about what's going on in court. So you want someone you can be flexible, you can work with, communicate well with, and is experienced and ready to go to court if necessary. Now, working with your lawyer, what I found helpful as a lawyer was when clients could summarize information for me. And one of the most helpful things I found was a 2 or 3 page summary of the case, maybe even bullet points, not necessarily, but could be bullet points or paragraphs that summarize the case. So the first time I'd meet with the client, they'd say, here's kind of a quick summary of my case, ideally a page or 2. So you're not saying all the details, but you're saying what's the key points that lawyers need to know, and to know how bad your case is. Because sometimes cases sound like they're really, not very serious, and yet they may be very serious. So you want to say some of the worst examples. And I mentioned in my book Splitting, which I mentioned a few minutes ago, there's chapter 14 talks about how to present your case. And it's how you can present your case in court, but also how you can present your case to a potential lawyer. Is talk about your 3 biggest areas of concern, like patterns of behavior, like the other parent makes a lot of false statements, or the other parent is angry and vindictive, and here's examples. So that, you have 3, maybe 4 categories of your biggest concerns, and then 3 examples of the worst behavior about those concerns by the other parent, and have that, say, in a 2-page summary, and give that to the lawyer. And the lawyer pretty quickly can go, oh, okay, I see what you're talking about. Or, oh, that's really minor. That's not going to be a winning argument in court. Or maybe this is a case you really want to settle because you have a lot of exposure to hostile decisions coming from court based on the information. So I find it really helpful as a lawyer when someone does that kind of a summary. Ask the lawyer how you can help and what can I provide information, etc. Now, phone calls with lawyers, this is one of the things people don't realize. Lawyers do a lot of their work over the phone, and so they charge for that. A lot of lawyers charge by tenths of an hour. So you have 6 minutes is a tenth of an hour. So you have a 2-minute phone call that's going to cost you 6 minutes. It's going to cost you a tenth of their hourly rate. So think about this. You may want to organize questions so that you call when you have several questions, or putting them in an email and find out how your lawyer communicates. Is it better to leave a voicemail, an email? Do they have an assistant that you can talk to and leave a message with? Be prepared for rumors and false allegations, because these are generally high conflict cases with someone who really wants control of the child trying to shut you out. And so they're often angry, they often distort things. And so you want to prepare with your lawyer. If you hear things about me, please check with me so I can say if they're true or not. And the lawyer's going to want to, you're going to do the same, because you may hear about your lawyer, maybe your ex-partner or co-parent says, your lawyer's stupid or really disliked or disrespected in the community. My lawyer told me your lawyer's, terrible. Well, don't assume that that's true. Talk to your lawyer, work out, find out what's being complained about. So that's something to consider. So don't assume things. Now, I want to talk just real briefly about the 5-factor model, because you want to look for information that helps your lawyer explain why yours is an alienation case and not, say, a child abuse or a domestic violence case, that's not why the child resists being with you. So the first factor, of course, is that the child has some resistance. Second is that you had a prior positive relationship. And so evidence of that, photographs, letters, written things, whatever, that information is going to be helpful. 3, the absence of abuse or neglect or seriously deficient parenting. So you want to be able to show that that's what's happening. Now, if you have been abusive, neglectful, or deficient, or there's somebody's made decisions like that about you, you want to show information why, if that's true, that's been addressed and no longer a problem. And if that's never been a problem, you need to emphasize that. So say I've got a consultation case that's being assumed that my client, the one I'm assisting and assisting his lawyer, assume that he's done something when there's no history of abuse in the case. And so allegations that he's been abusive have been thoroughly checked out and there's no history like that. You need to emphasize that. This is not a case. I have never been alleged to have been abusive. The 4th is multiple alienating behaviors. I mentioned earlier, parental alienation syndrome isn't a winning phrase in court. You want to talk about alienating behaviors. That's what judges and lawyers look at now. So you want to look at what are those. If a child resists, doesn't necessarily mean it's because of alienating behaviors. It could be because of child abuse or something else, maybe developmental stage, etc. So you need to identify if there are alienating behaviors you know about from texts, emails, etc. That's what your lawyer needs to know, not just that the child was resistant. That's not sufficient. You need to show that the other parent is the cause of that. And then the 8 behavioral manifestations. And just real briefly, here's a slide showing those. And evidence about these, again, would be helpful for your lawyer. So providing evidence of each factor to your lawyer, when did the resistance or refusal begin? I often ask that. What's the story of when did that begin? Because that often shows where it began from, what was happening that caused that. History of the good relationship, history about abuse, describing alienating behaviors, and the behavioral manifestations. Working with experts is another issue, and work with your lawyer about that. Ideally, you have a neutral court-appointed expert. That's who's going to have the most credibility. If you get your own expert and your expert says, I've talked to my client or I've just looked at documents and here's my conclusion, that's not going to be appropriate. It may or may not be accepted in court, but some professionals say that that's unethical. So if you're getting someone that's on your side, you want them to help you understand the case, to help assert your point of view, but not to do a neutral evaluation because they're not neutral. So there's the evaluator, expert, and then there's your separate expert, which you can have, and who can criticize an evaluation that doesn't look very good and may have not been done very well. You're allowed to have that in most states. So work with your lawyer on something like that. So that's my half hour. Here's some resources, several books. I've mentioned the Splitting book, which is the one I think most helpful for alienation issues, as well as child abuse, domestic violence, etc. It's a good education for everybody because all of these are possible, and you want to show why, in your case, alienation is what's happening. And so understand all the possibilities. BIF for communication, don't alienate the kids, of course, gives you the big picture on alienation. And calming upset people with EAR may help you communicate with the opposing party, keeping things calm so they don't backfire on you. The last thing I want to mention is changing lawyers. It's really not recommended to do that much. Doing that once is not a problem. You find out your lawyer's not ready, not familiar, and so you need to change, and you do research and pick someone who is going to be better and will stick with you. If you go through 5, 6, 7 lawyers, that looks to the court like you have a relationship problem. So you want to be cautious about that. But if you find your first lawyer isn't really the one and you have a better lawyer available, go with that better lawyer. You're not going to be looked at askance for that. I hope that's helpful. Best wishes.
Next week on Families Divided TV, Randy Fine gives us some strategies for dealing with narcissistic people.